introduce our guest today. The Honorable Judge Brown has been a part of the judiciary since 2001, nearly 20 years. He began his career at the Harris County Civil District Court and then was at the Texas 14th Court of Appeals before ultimately being appointed to the Texas Supreme Court in 2013, where he was for 3 years before he was appointed to the federal court here in the Southern District. He also graduated from University of Houston Law Center, like our other guest, Judge Sheldon. Judge Sheldon started his career in private practice before serving as an assistant U.S. attorney in the Southern District of Texas. He also worked at the Department of Justice in the Healthcare Fraud Unit and was a partner at Quinn Emanuel and their healthcare group before being appointed in 2018 to the court. So thank you both for joining us today.
Pleased to be here.
Thank you.
And I know I decide to start there.
Melanie, my Zoom froze for a second. So if you have asked me a question, I missed it.
Yeah.
Oh, I'm sorry. I'll repeat. I know I ran through a very quick version of your biographies, but just to go back to the very beginning of your legal careers, where did you start working after law school and how did you make that initial decision to begin your career there?
My first job was as a law clerk at the Texas Supreme Court. And I don't even think I knew that, I didn't even know what a judicial clerkship was before I went to law school, but I learned about it at law school. And once I learned about it, I really thought that'd be a good way to start my career, to transition from school into practice. And I was hired by Jack Hightower, who was on the court at the time and retired while I was clerking for him. And Governor Bush appointed a trial judge from Houston named Greg Abbott to replace Hightower. And so I had 5 months with Hightower and 7 months with Abbott. And it was a great first year to practice. And then I came to Houston and went to Baker Botts.
So for me, the most important thing to me was getting back to my hometown of San Diego, California. So the second summer was a summer associate at a firm called Cozen O'Connor that's now in Houston, but there was a San Diego office. So I didn't care what I was going to be doing as long as I could get to San Diego. That's what I wanted. And so I started my career there for 7 years doing all types of civil litigation.
And so both of you, it sounds like you started, you were working in civil litigation at some point and before transitioning into public service. For Judge Brown, that meant serving as a judge in Harris County District Court, and for Judge Sheldon, you were a prosecutor. So what made you decide to make the transition from private practice to public service?
You know, I think I was always interested in public service, and I think I attribute a lot of that to my dad was a police officer for 35 years, something that you would know something about.
Yes.
Ms. Guzman.
My dad's also a police officer.
And so I think that was already kind of in my blood, but it was the clerkship in Austin that first made me interested in becoming a judge. So I think, and it was working, and especially once Abbott showed up, and he was, he had just come off the trial bench in Houston, and it sounded like a lot of fun and very rewarding. And so I was fortunate enough to get to do it at a young age.
So for me, it was, I had been practicing for 10 years, doing civil litigation. I was involved in a lot of pro bono work. So I really wanted to be a trial lawyer. And on the civil side, it's really hard to try cases. If you try one case a year as a civil lawyer, that's considered a lot. And I had 4 trials in 10 years, and that was more than most of my friends that were civil lawyers. And so the opportunity, and especially where I went in Laredo, which was one of the busiest areas, was one, I wanted to feel like I had some sense of purpose or passion every day working for the government, and then to be able to try cases on a monthly basis. And that's what I got as a federal prosecutor. Both of those things where every day I had a sense of purpose, and then being able to be in a courtroom and try cases. I mean, it's really hard to get good at something unless you're doing it all the time. And I almost equate to trying cases as being a stand-up comedian, that before you can even be funny as a comedian, you have to get used to the lights and the people. And that's the same thing as a trial lawyer. Before you can get good at it, you have to get used to standing up in front of a jury and a judge. And I always say that it's trying cases is like having a conversation. The more that you can have a conversation either through direct exam, cross-exam, or with the jury in closing or opening, and you just can't get to that point unless you do it. You're doing it with a lot of frequency.
Definitely. And Judge Sheldon, this question is for you. Was there a particular experience while you were working as a prosecutor where you thought, wow, I would really like to be on the other side of this courtroom? Did you realize in your experience prosecuting cases that influenced you to want to be a federal judge?
I mean, I think so. The natural progression was I had moved to Washington, D.C., where I was a prosecutor for 3 years for the Maine Department of Justice. And then I hit the point where I had 3 kids that I had to leave to pay for their college. So I went to private practice. But I've always really, and most of you all are in private practice, but I've always just dreaded it because there's the good that you make more money, but there's the bad that you don't have that sense of purpose. And every day for that 6 years of representing the United States, I felt like I had a sense of purpose. And so at that point in my career, I'd been a federal prosecutor. I'd been on the defense side doing white collar criminal defense, that I thought the next step of leaving at that point in my career was to become a judge.
Yes, that makes a lot of sense. And I have the same kind of question for you, Judge Brown. You were serving the Texas Judiciary for so many years, and you reached the Texas Supreme Court. And then what made you want to continue to be a judge, but for the federal courts after having served so long for the Texas bar? What inspired you to make that transition?
You know, I started off, I was a trial judge for 6 years there in Harris County, and then on the appellate bench, either on the Court of Appeals or the Supreme Court for 12 years after that. And so part of the appeal of the federal bench was going back to being a trial judge again and running my own court, having my own docket. And part of it was clearly not having to run for election anymore, having a lifetime appointment. That was a big part of it too. And just a new challenge as well. I'm at this point in my career, you don't necessarily expect to be learning a bunch of new stuff all the time, but I am learning a lot of new stuff all the time. There are entire areas of federal law that I had never knew. But it's been a good change for me, and I've enjoyed it, and I feel very blessed to have had the career that I've had and get to do all the different things that I've gotten to do.
Of course, and you can be as judicious as you want in this question, but which of the Texas courts do you think you missed the most, or which was your favorite while you were there? I won't tell Justice Hecht if you don't pick the Texas Supreme Court.
You know, that's very that's pretty tough. I guess the Supreme Court is probably the one that I miss the most, and at all of them, what I miss are the people who I worked with there more than anything else. And I got to work with some great people at all 3 of those stops along the way. The Supreme Court, you know, it's a very heady experience. You're getting to the questions of law that you get are. I mean, we're at the Supreme Court. The Constitution, under the state Constitution, we were obliged to take cases that were important to the jurisprudence of the state. That's exactly the term that we were to use. And so you couldn't help but get a lot of interesting stuff. And then it's a fascinating experience to be in that conference room with those 8 other jurists and figure out how we're going to dispose of this case. And I miss the folks there, and I miss kind of the heady experience of being at the Supreme Court.
And I can imagine, Judge Sheldon, that would apply somewhat similar to you moving from being a partner at a law firm. It's a very collaborative environment, to transitioning to being a magistrate judge. Was it difficult to make the transition from private practice to the judiciary, or did it feel you have a community here as well?
So two things. One, I think, and most of you know, that the practice of law for a big firm, because the benefits of the high pay for everybody from the starting associates up to the partners has created this demand, client demand, that the clients are paying a lot of money and they want to win. And so in order to get that money, you have to be accessible. And then with the evolution of smartphones and the internet and everything else, that when Judge Brown and I first started practicing law, it was a lot different. That when you went home, it was really hard for someone to get a hold of you. There was none of these forms of communication. So it really had to be an emergency for somebody to call your home phone to want you, versus now 24 hours a day, someone can get a hold of you. And so when you're practicing at a big law firm like I was, there was, 24 hours a day you were on call. There was no real vacations. You were always needed because the client expectations were so high. And then as a partner, your expectations to bring in business are even higher. That I've never looked back, other than, you miss the money, but I would always say to colleagues, every day when I would drive into that parking garage in DC and Quinton Manual, I'd feel a certain dread. There was never a certain excitement. And every day for the past 2 years, when I drive in either in Laredo or this courthouse, there's a sense of excitement and purpose when I get in that judge's elevator, that I'm excited to look forward to that day. And then there's also, again, the normal, I go on normal vacations, I spend time with my family. My family doesn't see like stress or dread over me. So you become, I think a better person. I'm not downplaying private practice, but the one thing I always say to young lawyers is, if you had debt from law school, you really need to manage that debt now, because that really precludes you from ever public service jobs. But you'll see, if you have the chance, no matter if a federal prosecutor, a federal defender, or a judge, we're practicing the purest form of law. Everything we do there's no other thing that drives us other than doing the right thing. And when you can do that as an attorney, it's just an incredible sense of satisfaction that you'll get in the profession.
Thank you for sharing that experience. I think given that most of us are young lawyers, we're very familiar with the debt that law school can accrue. Going back to your experience at the court now, does cases before, but do you take certain things into consideration now, given that experience, especially for criminal cases?
I think we lost you. We've been freezing.
Oh, sorry. This is the court email seems to be, or the court Wi-Fi is messing with us today. I'm sorry. I'll repeat the question, Judge Sheldon. Just from your experience as a prosecutor, does that affect how you approach cases now, particularly criminal cases? Having worked those through from when the indictment is filed to trial, does that influence your experience now, how you manage your docket?
I think the great thing for me was the first part of the 10 years of my career, I was doing pro bono federal cases, representing people pro bono with long drug sentences, and then to become a prosecutor, prosecuting people, and then 5 years at a big firm doing white collar. That I've walked in both a prosecutor's shoes and a defense attorney's shoes, so I don't look at a case with a certain lens. I think as a magistrate judge, we don't sentence people unless it's here, especially in Houston, unless it's a misdemeanor, which there's few. But the biggest decisions that we make on the criminal side of magistrate judges are with bond, and those are the hardest thing, whether someone will be detained pre-trial. And I think that you get a better understanding when the government's asking for someone to be detained of when you've been a prosecutor and you kind of understand. It gives you more of an insight of what's really going on.
Definitely. And Judge Brown, I know that you didn't see criminal cases at the Texas Supreme Court, but you had background at the Court of Appeals. Was it difficult transitioning back into having a criminal docket again, or does the kind of work that you did at the Supreme Court apply even in the criminal context?
You know, it's definitely been an adjustment. When I was a state trial judge, I was a civil only docket, and then on the Supreme Court, civil only too, as you said. And at the Court of Appeals, I had criminal jurisdiction, but it was appellate jurisdiction. So this is my first time to have criminal cases as a trial judge. The nice thing is that in Galveston, I have a very small number. It's not nice that I have a small number of criminal matters, but it's nice for me to get my feet under me and learn this new area of the law for me. But I have really enjoyed it. I've enjoyed the variety that it brings to what I get to do every day, and it's been nice to have some. I'm signing off on wiretaps and handling these big drug trafficking conspiracy cases, and it's been fascinating work, and I've really enjoyed it. And you know, lawyering is lawyering, judging is judging is judging. So it's a new area of the law, but it's still applying the same skills that I applied as a lawyer and that I have applied as a judge for a long time.
But to echo on what Judge Brown, I think the fascinating thing is, this is my 23rd year law, that now being in Houston on the civil side, I'm facing issues and cases that I never have in my career. And while it's a little scary, it is exciting. I mean, it's intellectually stimulating to be dealing with issues that you never thought about, and when there's good lawyering on both sides and you're weighing those. And I think back to one of the points you made too, also, in law firms now, at big firms in some of these cases, you have 25 people on a case, which is a whole army of lawyers. But sometimes as a senior lawyer, you don't have interaction with the first or second years. And I think that's the other neat thing about becoming a judge, is you really do have a lot of interaction with your clerks. And I think it's good for both that, like, I've done more writing and editing than I had in 10 years, now that I did, because at a big law firm, it's filtering its way up to you, that there's a lot less editing. But I think it's great experience for the judge and the law clerk.
Well, and I'm glad you brought up law clerks, because I don't know how I'd be doing it without them. When I was on the state trial bench, I didn't have any law clerks, and I had a much bigger docket of cases too. Now I have a smaller docket, and I have law clerk help, and I've had law clerks now since I was on the Court of Appeals, and it is one of the most rewarding things about being a judge, is that relationship that you have with your law clerks, and it keeps the law fun and exciting, because it's all new to them, and it's fun and exciting for them, and they're not jaded old lawyers who are tired of what they're doing. They're wide-eyed and enthusiastic about it, and so we've been able to learn about these things together, and it's been very rewarding.
And I know we have some students attending, some law students, attendees, as well as people who haven't clerked. And I guess for those who are less familiar, what role does the clerk play to support you both? I know it differs depending on, in the appellate context, Judge Brown, and in the district court context that you are now. But how do clerks? How do you rely on your clerks in the day-to-day of your docket management?
I have 3 clerks, and I have my docket divided into thirds, and so each one of those clerks is assigned to a third of the docket, and whatever cases come up in that part of the docket, whether it's a bench memo to help prepare me for a hearing that I'm going to do, or first draft of an opinion that I have to prepare on a motion to dismiss or a motion for summary judgment. Or I did a rearrangement this morning, and the clerk who was assigned to that case provided me it was essentially a script to follow to make sure that I hit all of the points that I needed to hit to make sure that arraignment was done correctly. So they're research assistants, they're writing assistants, and they're kind of strategizing assistants too when we're trying to figure out exactly how to handle a problem that has come up in a case. I'll meet with my clerk and we'll kind of brainstorm it and come up with a resolution.
And
Do you use clerks in kind of the same way, Judge Sheldon?
Yeah, exactly. So here it's different. In Laredo, all I had was a criminal docket. And so the way the cases were referred from the district judges, we would do the motions to suppress would be referred to us. And those would be the biggest writing assignments. I would hold an evidentiary hearing. And then after the hearing, we would do what's called a report and recommendation that would go to the district judge. But those could be lengthy, and they could be over 25 pages. And a lot of times your opinion can be the operative opinion that's going to be, because the district judge may affirm or adopt what you're doing, but they're not writing a separate opinion. And so what your opinion is really important because that's one that the Fifth Circuit's going to rely on. In Houston, it's different. It's, I have a lot of civil cases. And so in a civil case, the parties can consent to a magistrate judge, meaning that now you basically sit in the same shoes as a district judge for all purposes of the case, or it's assigned to you. If they don't consent, you handle everything pre-trial up to the trial. And so a lot of these cases, lengthy motions for summary judgment are filed. And that's really your clerk's biggest assignment is how we manage all these motions for summary judgment, where I referred again, I mean, you have multiple attorneys on both sides and there's just you and your clerk. And so my clerk will do the first draft on all of these, what we call memorandum of recommendations. And so I love to hear their initial thoughts, and it's neat because you don't, when you interview someone, you're not ever discussing politics or what their judicial philosophy is, because that, to me, that's not really relevant. It's whether they're smart or not. And then, so you don't really know what perspective. And so it's fun debating these things. And so on those, I like to see how the clerk goes. I mean, ultimately, it's my decision, but it's just interesting because you want to see if they're on the same. And sometimes, we're not on the same, how we think the case should be resolved or not. And a lot of times it's just your feel for it as being a trial lawyer, being in practice, versus you all are just so new that you have all that theory from law school, and you're just learning where that theory and the practical realities of law really intersect when you start your career.
That's Judge Brown.
Well, Judge Sheldon brought up an interesting point when he talked about how different his docket was in Laredo versus his docket in Houston. And that's something that I think is lost on a lot of lawyers. And it was lost on me before I got into the federal courts, that the caseload in Corpus Christi and Brownsville and McAllen and Laredo is very different from the caseload in Houston and Galveston. We're a very civil heavy docket here. I have very few criminal cases, but it's interesting, in Galveston, I've got over 100 prisoner cases, which are, it's civil cases that prisoners have brought for constitutional violations. The types of cases that a federal judge can handle will vary a lot from forum to forum and venue to venue. And I don't think a lot of people realize that.
Certainly. And speaking of the kind of civil cases that you might have, I know that there's at least 500 civil cases in your docket. So that certainly covers a wider range of topics and causes of action, areas of law. And I know that every district court judge or every judge in the Southern District has a different way of managing those kinds of cases. And this answer might differ for both of you, but how do you move, what's your style for moving through the docket? Do you encourage motion hearings, or do you encourage the parties to settle if they reach an impasse? In the before times, were you ready to go to trial more often than not? I know that that's been put on hold at the moment, obviously with the court ordered hold on trials, but how do you manage your civil docket?
It's different than the way I managed it when I was on the state court trial bench, because my caseload was, I had so many more cases when I was on the state trial bench. It would kind of force me to push mediation and ADR a little more than it does now. Since being on the federal bench, I haven't ordered anybody to mediation. I have encouraged it when I thought it would help a particular case. And the great thing about the federal courts is magistrate judges like Judge Sheldon and Judge Andy Edison, who works with me, can mediate cases for free, and they often do a great job at it. And so I haven't made anybody go to mediation, but I've certainly encouraged them to go when and made them aware of that the opportunity to go to a magistrate judge. I like hearings, so if there's any question on whether a hearing might help to resolve a motion, I'll go ahead and schedule one. We've been doing those over the phone or over Zoom for the most part in our civil cases since the pandemic hit. But we were doing a lot of them over the phone before the pandemic hit, just because so many of my cases involve lawyers from Houston, and if I'm going to have a 10-minute hearing, I'm not going to ask them to drive all the way down to the island for just a 10-minute hearing. We can get them on the phone real fast. I am less. It seemed like as a state court trial judge, I was more just reactive because there were so many cases that I'm able to be a little more proactive as a federal judge and direct my cases a little bit more, and that's been enjoyable.
Certainly. And do you? Oh, sorry, Judge Sheldon.
I was going to say, so the mediation, as Judge Brown said, so the district judge can refer us a case for mediation. That's our only role in the case. We're not going to manage the case and then mediate it, because the parties will tell us confidential information in the mediation. But Judge Eskridge assigned me a whole bunch of cases, and that's probably been, I've been doing a mediation a day this week and next week, and I'm in one right now on a break. But that's been the most enjoyable job. I mean, it's just fascinating, you as the mediator getting to play that role, and especially as a judge, because the parties know that I'm not trying to get future business. I don't have to worry about hurting people's feelings and not getting, people wanting me, that I can give honest opinions. And we don't ever discuss the outcome what the district judge assigns us. We just tell them whether the case settled or not. But what we can do is, like with Judge Eskridge, the cases that he assigns, all the briefings been done on the summary judgment. And so I can tell parties, look, I think I'm not going to discuss it, but, based on, and Judge Eskridge, and I knew Judge Eskridge, I can say, I think he may rule this way or may not rule this way, or lose. And that's a valuable role, because there's no motivation or bias in us telling parties. We're not driven by anything else besides that. But that's been really the most enjoyable part so far, is conducting mediations. On managing the docket, I think as somebody that I try to be the judge that I wanted to be, wanted the judge to be in like civil cases. And the problem that you realize is you're like, oh, that's why the judge was that certain way, because parties can be crazy, so you try to be really responsive and hold hearings. And then you always have, like, in a case where both attorneys are crazy, and you're just suddenly, Judge Brown had a lot heavier docket. Suddenly you're like, I have all these cases to manage, but there's this one case that every day I wake up to new filings that want me to get involved. And it's like a parent trying to resolve kids, fight between two little toddlers. And so that's the fine line that you draw when you put too much attention into a case. They think you're always there, where you want the parties to resolve these things on their own.
And I just wanted to touch on something you said. You were talking, Judge Sheldon, about doing settlements for the district judge and anticipating how they're going to rule. Relatedly, do you think that those kinds of alternative dispute resolutions will be more relied upon now that trials have been delayed, at least until October? Do you think parties are going to be more inclined to ask for mediation with the magistrate judge, or to pursue those alternative remedies if they aren't able to push a trial anytime soon?
I don't know. I mean, with us, there's no, the way I look at it, there's no harm with the magistrate judge because it's not costing them any money. They don't have to pay for it. So I look at it like,
Mhm.
why not just try? You never know. And I look at it like when I'm doing it, my sense of satisfaction is I know that the district judges have a lot of cases. So every case I resolve is one less headache for them. But I think
Mhm.
the parties, because we're just starting back with trials pretty soon, I think there'll be a preference with criminal, that it would be foolish for them not to try to do everything they can to resolve the case, especially when we don't know when we're going to get back to normal with trials.
And Judge Brown, are you seeing more settlements on your end? And likewise, do you anticipate having to do more things over Zoom to resolve cases, like maybe a Zoom bench trial or even a Zoom jury trial?
Well, I don't know that we're seeing more settlements. The inability to, the best way to get a case settled, aside from sending it to a good magistrate judge to get it settled at a mediation, is a jury trial, is setting them for a jury trial. And we have not been able to do that for a while. That is coming to an end. I will start setting cases for jury trials in November, so that we have time to summon the jurors between now and then that we'll need to pick the juries from. But I don't know that we've seen more settlements during the pandemic. I would have been willing to do a bench trial on Zoom. I don't know that I would have tried a jury trial on Zoom. I think that has happened in other parts of the state, but I don't know that I would have given that a try. I know that Judge Rosenthal has done bench trials on Zoom, and maybe some other judges have too. And I think that would work, but a jury trial would be pretty hard to do over Zoom. And I'll be glad when we can have jurors back in the courthouse here pretty soon.
And
Yeah,
Judge Sheldon.
I did a criminal bench trial on Zoom of a serious misdemeanor case. It worked out. I mean, the whole world's changing with Zoom. At first, I mean, you have certain frustrations where you just want to pull out your hair when, like even with this, when we lose the connection or you lose a certain witness, or we do a lot of hearings at the jail, and if they drop off, it can take 30 minutes to get them back on. And so there's been a lot of efficiency. That trial was, that I had was fine, but I agree with Judge Brown. I don't know if I'd want a jury trial because, part of a jury trial is you as a lawyer being able to effectively communicate, engage the jurors. And I just don't know how well you could do that on Zoom. I mean, it's amazing now how people are taking depositions by Zoom, and the whole practice is changing and doing status conferences and criminal hearings. But so it will be interesting to see what happens when hopefully we get back to normal soon. But I don't know if I'd ever want to do a jury trial. If I was the parties, whether I'd ever want to do a jury trial by Zoom.
Certainly. And I know neither of you are epidemiologists, so we can't predict the future in terms of where the COVID-19 pandemic will take us. But there, as you said, Judge Sheldon, there has been a lot of changes to the litigation practice in general. Do you think that some of these changes are here to say, maybe counsel will be like, why were we ever taking depositions in person? Like Zoom's depositions are great. Or do you think that some of these changes are just kind of temporary stopgap measures, but things will resume to in-person proceedings as soon as feasible?
I don't know about the depositions, but I think the in-court appearances for civil, so I think it's more efficient for us, more efficient for the parties, that they don't have to leave their law firm. That I think those will definitely, the actual status conferences on 95% of motion practice. I think Zoom is probably going to be here for good even when we get back to normal, just because of the efficiency. With the depositions, it's different because you have certain gamesmanship that parties are always worried about, coaching witnesses and not being in the same room, or even, I think there's a lot to say that when you're cross-examining somebody on an important case in a deposition, you really want to be 3 feet apart from that person and not by video. I think it's harder sometimes to elicit important information by video than if you were right in the same room with them.
two things that I think are going to continue to occur on Zoom, even once everything is back to normal, are I have a lot of friends who are arbitrators, and they say it's been great. An arbitration is basically a bench trial. Bench trials are going to be a lot easier to do over Zoom than a jury trial is. But also what they have said is that very frequently, especially in these big commercial matters, you've got witnesses far flung across the country, and getting an arbitration done in person used to be a hassle because you were dealing with the schedules of these witnesses who were having to travel in from around the country. And now on Zoom, it hasn't been that's gone away. New York that week is no longer a good excuse. You can just get them on Zoom and handle them that way. Another thing that I think is going to continue on Zoom, and probably the thing that I've enjoyed most on Zoom, is interviewing law clerk applicants. Because it used to be, if I wanted to interview them in person, the federal government is not going to pay for them to come down here if they're coming from another part of the country. But I can get them on Zoom real fast, even if they're just up the road in Houston or over in Austin or Lubbock or Dallas or whatever, or even farther away than that. So I think that I'll probably continue to interview law clerk folks on Zoom, even once the pandemic is long gone. That was eye-opening for me.
And I think at first I was like, how do you conduct a mediation by Zoom? But I think that's probably here to stay too, because it's been effective. It's a lot easier for the parties because you have, let's say, you have a defendant that has a commercial client, and their clients in Connecticut, they always dreaded having to be in person, versus now, you have these virtual breakout rooms. So you put the parties, and you can have multiple parties, and I think it's been effective. I was shocked at how effective that I didn't feel that there was a lot less effective being in the actual room, that doing it this way has been good.
Yes, I think the travel expenses, as both of you guys mentioned, and Judge Brown, in the context of clerks, are something that's been eliminated, and that's going to be cheaper for law students applying for clerkships. It's going to be cheaper for law firms when they're doing mediations and hearings. So that definitely, that seems like something that might stay permanent. Relatedly, talking about motion hearings that are conducted by Zoom, I imagine both of you have been holding those for the past few months. What are some effective oral advocacy strategies that you've seen? I know that it's different, arguing before a judge in court versus arguing the same motion by Zoom. Do you have any tips or pointers for litigators who have like a big motion hearing on Zoom, or even a bench trial? Any effective strategies for handling those kinds of things?
I think the best advice is just to make it as much like you are there live in the courtroom as you can. And that means that you're not doing it in your pajamas, and the background on your Zoom background doesn't matter that much, but something that's not distracting, something that's serious is advisable. And otherwise, just kind of treat it as it's a serious matter, and treat it like a serious matter. And I think that that's the best tip that I could give.
And I echo that. It's funny because you think these things are common sense, but I would say over half my hearings, people aren't professionally dressed. And so if you don't, as Judge Brown just said, if you don't look like a lawyer, it's hard for the judge to look at you, take what you're saying seriously. So I'm not even talking about people not having a jacket or tie. I'm talking about people wearing jerseys or just shorts and a t-shirt. Wow. That you would just defy common sense. Second thing is if it's your first time on Zoom, and your hearing's at 9, you don't want to be waiting till 8:58 to figure out if it works. Like, you really want to check out your Zoom the day before. And if you're going to share your screen and use documents, you want to do all that before the actual hearing starts, because people don't realize that judges have limited time, and if you're not there, you can't figure out how it works. And I think if you're going to be using a lot of documents, there's never anything wrong with copying the other side and sending them to the case manager. So I have, I have a copy of the documents that you want to use so I can print out, and even though it may be on a screen, if I can't see it, I have it. So a lot of common sense things that don't even have to do with the substance of your argument that I see people that don't do, and then it takes away from the actual substance of what they're trying to say.
The Jersey anecdote is pretty shocking to me. So hopefully that was no one on this webinar, that it's still federal court. But we did get a question from one of our attendees. Going back to mediations, someone asked, what are the factors for having a successful mediation? And I guess both of you could answer that question from the practical perspective and then the litigation.
I've never been a mediator. I've never mediated a case. I used to, when I was an advocate, I would go to mediations. And I think what is most effective for the advocates in a mediation is to come prepared as if you're prepared to go to trial. Part of what you're there to do is to convince the other side that if this case were to go to trial, it would come out your way, and it's in their interest to be reasonable about settling the case with you. And that comes from preparation. You can't just head down to mediation and think that the mediator and your client are going to do all the work. And you have to go prepared and to give the mediator the ammo that he or she needs to take to the other room or take to the other virtual chat room to convince the other side that they need to make a better offer.
So Judge Brown's magistrate judges assigned him as Judge Edison. And so I think the world of Judge Edison. And so when I started, I said to Judge Edison, what makes you, I mean, he wouldn't admit it, but he's a great mediator. I said, well, what makes you a great mediator? And he said two things. One, you can't start the mediation the day of the mediation. And so what he does is leading up to the mediation, he has multiple individual calls with the attorneys discussing the issues. And then the second thing he said is you have to be prepared, meaning that not what they provide you, you've got to read the motions, read the cases, and understand the issues as good as the parties. Otherwise, you really can't force them to confront certain bad facts unless you know the facts in their case. And so those are the best advice he's given me that he said. And I think from a party perspective, I think you have to know and be able to understand the bad facts in your case and your risk and have client management and be able to, it's really hard if the mediator is the person that's telling the party that, well, these are the negative things in your case, and you get the feeling like their own attorney has never shared with them the risk in their case of if they went to trial.
We actually have another question from the audience. This one relates to Zoom discovery hearings. Are those, the panel attendee asked, how do they feel about holding those via Zoom? Is that something that you guys are amenable to, have been relying on more often?
Yeah, I'm amenable to doing it over Zoom. I mean, I would prefer to avoid discovery hearings. They can be very tedious, and so and very often it's stuff that the lawyers ought to be able to work out between themselves. And lawyers have heard judges say this lots of times, so it's not news to anybody. I can see how for a couple of reasons how a discovery hearing might be better in person than on Zoom or over the phone. For one thing, where the lawyers are more likely to try and get it resolved to avoid having to go somewhere rather than just hop on the telephone. And for another thing, it's often when you are fighting over documents, it's helpful to be able to see the hard copies of the documents. That can be managed on Zoom, but a lot of times it's just easier in person. So I can see how an in-person hearing might be a little more effective than on Zoom. But lawyers have gotten very innovative in the way that they handle hearings over Zoom. And so I think a lot of those hurdles can be cleared.
Yeah, I've been conducting so far all my discovery hearing, but I started July 1st in Houston. So it was post-pandemic, or during the pandemic, so everything's been by Zoom.
We've talked a lot about oral advocacy, Zoom hearings and things like that, but what about written advocacy? Do you have, what are some examples of really strong motions, and what's a motion something not to put in your pleadings that you've seen based on your tenure at the court?
You know, one thing that what makes a bad written motion and what makes a good written motion are pretty much the same thing. I can tell you what makes a good one by telling you what makes a bad one. And one of the things that I have been very disappointed in is overly repetitive motions. You know, you really do only have to tell me something once, and I'm going to hear it that one time. It doesn't have to. If a 4-page motion will do, don't make it 6 or 8 or 10 by repeating yourself. And gosh, the cutting and pasting is just amazing. Cutting and pasting out of pleadings into motions. And I know that lawyers are busy and time is valuable, but I think that lawyers would serve themselves better to take some time and do some original work on a motion rather than cut and paste from other stuff that they've already filed in the case. And you'd be surprised how often we see that. And that's one way in which they get to be so repetitive, is that lawyers aren't taking the care to spend some time. It takes longer to do a 4-page motion than it does to do an 8-page. It's not about writing, it's about rewriting and editing. And lawyers need to spend more time doing that, and their motions will improve.
Yeah, I mean, writing to me is probably is the #1 trait that I've seen, because in the civil side, very few cases go to trial. And so, you know, from working at big law firms, the people that advance the highest generally are the best writers. And so I think writing is such a key thing. And as Judge Brown said, to me, less is better. I mean, the shorter it is, the more attention you're going to get from the judge versus people that think they need 50 and 75 pages. I mean, there's just no reason that it needs to be that long, and it's going to have more of an effect. Brevity is so important. I think besides the obvious things, like when people write distracting, when they put a bunch of things in bold or all caps, it just distracts me as the reader. And then overselling your argument, or just whenever, you know, accusing the other side of this completely is without merit or all this, I mean, it better not have, because if it's a questionable issue and you're just setting yourself up when you're selling it like that, when it really isn't. But I think shortness and as Judge Brown said, stop the cutting and pasting. I mean, that really, but the thing that I've always learned, and people taught me this as government lawyers, you only have the judge's trust once. Like once you violate that trust, the judge isn't going to believe you. And that's the most important thing, that when you're writing is be accurate and make sure that you're not misrepresenting the facts or the law. Again,
Sounds like more common sense strategies, Judge Sheldon. We're wrapping up on our time here. If anybody has any questions, please submit them. But I just wanted to ask you the same question, a question for you both, but phrased a little bit differently. So for Judge Brown, you have experience not only in federal court, but in state court, as we've discussed. And as you mentioned, in state court, you have elections, so the process is different. But for anybody who is interested in being a judge, particularly in state court and running for office, what advice would you give to a young attorney now? How can they prepare for being considered for that kind of role?
Well, there are two big boxes that need to get checked, and one of them is experience. You need to have the right kind of experience so that you can convince whoever you're trying to get to choose you to be a judge, whether it's the governor for an appointed position, whether it's the voters if you're running for election, whether it's the senators, which is the U.S. senators, which is where it really starts for a federal appointment. You have to be able to say that you've got the right kind of experience, and that the more courtroom experience, the better. And I know that that's the hardest kind of experience to come by, but you come by that by seeking it out and taking the opportunities when they come, and making time for them when they do come. The other big box to check is the politics box. And obviously, if you're going to run for election, you need to be active politically, because you're having to convince primary voters and general election voters to select you, and you run into those folks by being somewhat active politically, and even on the federal side, there's different kinds of politics. There's party politics, and there's the kind of politics that just makes you more visible to people, to influential people who are going to want to, who are looking for folks to put on the bench. And so you kind of have to be out there in the community, and you have to be seeking out the right kind of experience, so that when the opportunity comes, you can jump on it.
Certainly. And Judge Brown, we actually just got a question. I think it's directed towards you, but do you have any suggestions for attorneys that largely practice in state court that want to prepare for federal court practice?
Oh, that is, I don't know that I do. I will tell you some of the differences between state court practice and federal court practice. One thing is the procedures that each federal judge follows can vary a lot from judge to judge to judge, even in the same division, even in the same courthouse. So I would encourage, if you find yourself in federal court, to familiarize yourself with those individual procedures. It'll make your case go a lot smoother. It's very different. The federal court is a lot more about jurisdiction. It's about, there's motions to remand, motions to dismiss are things that don't happen in state court. And you've got to convince the federal court to keep your case first before you even get to the merits. So it makes it very different from state court practice. And familiarizing yourself with those processes, I think, is a good idea too.
So let me jump on. So my first 10 years were in state court in California, and I think what Judge Brown said is the same in California, that state court judges don't have law clerks like they do in federal court. And so California in state practice, you had a hearing on every motion. Nothing was just decided on the papers. And so the writing, people would just file whatever because they knew they had a chance to get up and argue. Where it's reverse, in my experience, in my practice, as a practicing attorney, very few judges would hold hearings. It would all be decided by the paper because they had the law clerks and the ability to issue. And so sometimes the lawyers didn't understand that they can't file, subpar paper because they're not going to get the chance to argue it. And the caseload is a lot less. And it just seems to me, and this is no way denigrating because I've practiced half my career in state court, it just seems that federal judges have a lot less patience for things than state court judges. And so you just have to be, on your tippy toes when you're in federal court.
That's a very good point. Written advocacy is very important in state court. It is even more important in federal court.
Those are great tips. Thank you, judges, for sharing that with our panelists. Judge Sheldon, my question for you, similar to Judge Brown's, given your background and your experience working in the Justice Department, I know that that's just not something that most attorneys in private practice can easily lateral toward the way they could another law firm. And so do you have any advice for someone who's doing civil litigation or criminal litigation in the private context to be able to become a U.S. attorney or otherwise work in the Department of Justice?
So you have 94 different judicial districts. Every one of those districts has a U.S. attorney. And so the more places that you're willing to go, the better chance. But you need to know for each U.S. attorney, there's a different philosophy of who they're going to hire. A lot of the districts, the U.S. attorney came from a big firm, and so they tend to favor people, even if you didn't have criminal experience, if you had, a judicial clerkship and you worked for a big firm and you went to a top 20 law school, they would favor that versus like the current U.S. attorney in Houston, he favors the opposite. He favors hiring people that were assistant district attorneys. And so you just have to figure out whatever division that you're applying to, what's the background they're looking for. But I think you can never go wrong if you want to be a, if you start out either as an assistant DA or if you want to be a federal prosecutor, if you're doing something on the other side, like if you're doing white collar defense, that you can show that you have experience or you have an interest in doing that. But I mean, I say, and I think this goes with Judge Brown was saying, that the caveat is always to network, and you always want to be qualified, but networking when there's opening in whatever positions always helps if you know people or people can refer you. I mean, that's besides being qualified. And so the more, participating in Houston Young Lawyers Association or other associations, that's always going to help your career.
Thank you. And that's a great note for us to end on. Thank you so much, Judge Sheldon and Judge Brown, for joining us today. This was very helpful, both of you. I know you have really busy schedules and Zoom hearings to go to, so we really appreciate that you took the time to speak with us and give us your perspective and offer advice for HILA attorneys.
Enjoyed it.
Thank you. Thank you. And I hope you both have a good afternoon. And thank you to everyone who attended today's event.
Thank you.
Stay tuned for the next one. Thank you.
All right. Bye-bye.
Bye.